rise. The Court of Appeals Division 1 is now in session.
Please be seated. Good morning. We are here for oral argument in case number CV220240, JD's River versus Maricopa, LCR. These proceedings are being video and audio recorded, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. The panel has read the briefs and discussed the case in conference. Judge Cruz is currently out of state attending a course on digital evidence for judges and will participate in today's argument remotely. Counsel, you may proceed.
Good morning. Thank you. Ross Meyer for Appellants, JD's River Bottom. This case essentially has two main questions. Number one, is a Board of Adjustment able to include conditions in a variance that it issues? And are those conditions enforceable by its own terms? And then secondly, whether my client's application for a variance, which was nearly identical to the one that was granted with conditions, was improperly denied by the county.
Counsel, why is this action not time barred under 11816D?
Because the appellants brought a special action in the lower court and for the denial of the variance, and then also upon discovery and matters that occurred in that case, brought the claim to include the county for its actions in not enforcing the Sunday goods variance.
But you're saying there's no deadline for bringing that action to enforce the conditions placed on Sunday goods?
Not in the statute. I believe and not as a property owner for the variance affecting their property. And I think that goes to the heart of why the Sunday goods variance can't be run with the land in perpetuity when it wasn't complied with, which is the argument we make that such letter agreements that are outside the Board of Adjustment don't provide the property owners the proper notice of what's occurring in their neighboring property and land that's next to them, because the Board of Adjustment required that actions occur within 120 days and a year.
But the variance is to have a business that's closer to a school or a park. What does it matter to the neighbors whether it's a new building or a remodeled building? How does that change the fact that a variance was given, that it's okay to have this type of business within this distance of a school or a park?
Right, and so it's okay to have that type of business near a park or a school when the site plans are complied with. Initially, the site plans were for.
But why is the site plan critical if the only difference is here they're remodeling a building as opposed to building a new one?
Because the site plans form the basis for the Board of Adjustment to maintain the zoning regulations and to ensure compliance with the zoning regulations. If it's just to say a business is going to be there, that might not comply with the purpose of the zoning regulations. If it's a certain type of construction with the site plans that were approved by the Board of Adjustment, then that does bring it towards the compliance with the zoning
regulations. But this doesn't have
ordinances.
anything to do with maintaining a buffer or something. It's not something along the lines of you should only have access to the back of the property or you should have some sort of screen. This is just...
No, I apologize if I cut you off.
No, go ahead.
It's the difference of a, for lack of a better term, a state-of-the-art 12,500 square feet marijuana business versus a remodeled one-room, 700 square feet business, and what that does in that area and what that does for the compliance overall with the zoning ordinances. And that change, the larger building, was approved by.
I guess I'm not following why it changes anything to do with the zoning ordinance. Whether it's a big building or a small building, it's zoned for this use.
Because the variance that allowed it to be zoned for that use had very specific aspects of it. That was the decision of the Board of Adjustment. And the Board of Adjustment's decision was, okay, we're comfortable with this type of business being at this area when it is close to a park and school, if it's these site plan approved documents, not just completely this type of business is permitted to operate here under any circumstances. And so that's the heart of the issue here is what occurs when, does the Board of Adjustment have that authority to impose conditions? And in the briefs, we indicate that there's the authority because they have to make their variances agree with the zoning ordinances overall. The appellees.
Council, what language in L816, B2 allows them to impose conditions?
It's that they're allowed to grant variances and preserve the general intent of the zoning ordinance. And so that question is, what is preserving the general intent of the zoning ordinance? And here it's not that the Board of Adjustment is approving certain site plans. Obviously, that's a different function within the county. But it can say, we grant this variance presuming you comply with the other portions of the zoning ordinance that are under other departments' discretion. And that makes sense, because if an applicant for a variance is not complying with the other ordinances that are under the purview of other departments, the Board of Adjustment wouldn't want to grant a variance that runs with the land in perpetuity. And so that's where it comes from. The statutes for the city and their boards of adjustment clearly state what can be done and what cannot be done. But
are you saying that the variance is automatically revoked by not doing something?
I'm saying on its own terms, on its face,
but
yes.
Wouldn't you agree that they could presumably excuse some minor departure from a site plan? Do we have to go in? Can you come in and say, oh yeah, you were supposed to have whatever design element, you didn't have it, therefore the variance no longer exists?
I believe the Board of Adjustment could make that decision and make that change and say, look, these were the March 2018 site plans that the variance was.
But here they have not.
Here they have not.
Isn't there an assumption then that they're comfortable with that there are some differences, but it's still the purpose of the variance has still been met regardless whether it's a new building or a remodeled old building?
I don't think so, because the March 2018 site plans have not been complied with at all. It's a different set of site plans. If the board then said, we're modifying and using the June 2019 site plans, I think that would be fall under that argument. But no, in a sense, it's saying if they're licensed to do medical marijuana, but they start doing recreational marijuana, well, the Board of Adjustment approved it because it allowed them to do medical marijuana. I don't think that follows. I think they would need a variance to do so.
Council, actually, I have a question related to that. Is there any requirement under the medical marijuana statutes requiring an entity to either pursue the variance first or the permit to sell marijuana in any particular? I mean, what comes first?
Yeah, so the way it works is in your application for medical marijuana, you need to receive from the local governing body, whether it's the city or a county, a letter stating that the property is properly zoned for medical marijuana or might be properly zoned for medical marijuana. There's a form from AZDHS that has a number of signatures for either a town manager or county manager to sign. And so to answer your question, you need to go through that process of getting the variance prior to submitting your application so that the land is properly zoned for a medical marijuana dispensary. But then after the certificate is issued, that's when the certificate of occupancy and other aspects come in. So it's a little of both. The form is not binding, but it does need to be executed prior to an application being granted.
Okay.
If there's not other questions, I'm going to reserve my time.
I would like you
Yeah.
to address what you think the peculiar conditions are relating to your client's property that require a variance.
Yeah, and they're the same peculiar conditions that were in the Sunday Goods application.
But what if part of it is it's an underserved it's a business that there's nothing like it. Does that factor into their analysis? And what sorry to just be rambling here, but what if they just got it wrong with Sunday Goods? Do you still have to show there are peculiar conditions for your property?
Yes, I don't think it follows that just because one variance was granted here, they're required to grant our variance. But I don't believe the county is saying they got it wrong. They're saying we didn't have the authority to impose these conditions, and they're saying the Sunday Goods variance is valid, and their peculiar circumstances are valid. And so I think in that sense,
are the properties identically shaped? Is that?
They're nearly identical in size, shape, the conditions around them.
Is there any Arizona authority suggesting that a legal condition such as the property size is sufficient to give rise to a peculiar condition?
I believe so. I will look at that while I'm listening.
Okay. Any other questions?
Okay. Thank you.
Good morning, Your Honor. My name is Sean Moore. I'm with the Maricopa County Attorney's Office. I represent the defendants and appellees in this matter. With me at council table is Wayne Peck. As a quick programming note, I'm here to handle the procedural and jurisdictional issues, and Wayne's here to handle the substantive land use issues. I'm hoping to only take maybe 7-ish minutes, depending on your level of interest. So if you're more or less interested in what I have to say, let me know. So one of my main goals is to clarify something that's been repeatedly confused throughout JD's briefing and presentation here today, which is the fact that there are two separate cases here together, and they concern different issues, and they have different defendants, and it's relevant to a number of the issues in this case. In the special action, in which Director Pekorski and Maricopa County are named as defendants, JD's asked the court to invalidate the Sunday Goods variance. On the other hand, in the statutory appeal, which has the Board of Adjustment and the county as defendants, JD's asked for the court to reverse the denial of its application for a variance. A good example of them conflating these issues can be seen in their argument responding to the fact why Maricopa County is not a proper party in the statutory appeal. In the answering brief, we pointed out that the statutory action is taken pursuant to ARS 11-816, which permits an action against the Board of Adjustment if you are aggrieved by denial of an application for a variance. There's no mention made of the county and no allegation that the county had any involvement whatsoever in the variance application review and denial process. In its reply brief, JD's argues that the county was involved in the letter stating that the conditions by which the Sunday goods variance were considered to be satisfied, meant that it was involved in the situation and therefore its presence in the statutory appeal is proper. But what they're doing is they're conflating the two different cases in this matter. They're taking something from the special action and saying, oh, because the county did something in the special action, it should pertain to the statutory appeal as well. And that's a problem that comes up time and time again in their briefing. This can also be seen again in their argument concerning why there's how we point out that we don't believe there's a final judgment in the statutory appeal. As the county pointed out, there's a final judgment entered in the special action, but not for the statutory appeal. In their reply brief, what they say, they quote language directly from the judgment that says, hey, there's final judgment and whatnot. But the case number used in that judgment are only for the special action, and the defendants in which judgment is entered in their favors are the defendants for the special action and not for the statutory appeal. So when they point that out, they're again conflating the two issues, even though they're separate. Now, moving on to the special action. JD's does not have standing to challenge the Sunday goods variance because they do not suffer any particularized individual harm from the grant of the Sunday goods variance.
Counsel, assuming under any theory brought by JD, that there's something somehow improper about the Sunday goods ordinance, how is that not an injury?
Because they don't, whether or not the Sunday goods variance is there doesn't change their status whatsoever, because JD's never has any chance of opening a medical marijuana dispensary because they're not legally organized in a way where they can operate such a dispensary. So in either case, whether or not they...
You make that assertion, but what if they have a tenant in mind that may be qualified to operate in that manner? Why, as the owner of the land, why wouldn't that give them an interest or a potential interest in it?
Well, I think that's the kind of speculative injury that doesn't qualify someone to engage in standing. There's no evidence in the record that they have any tenant like that lined up. But it's, if they have a tenant, and if that tenant is organized to get a medical marijuana dispensary certificate, and they are actually able to get it from ADHS, and the actual owner of the property is willing to go along with it, there are so many contingencies.
Suggested that it might be something you need to do first to be able to show that you have some property, you have a place that's in a location that can be zoned for that purpose.
Correct.
So why you're saying you have to get all the permissions first before doing the zoning? I'm not sure I'm following exactly why you have to do it in that order.
Well, I'm not saying there has to be an order. What I'm saying is that there are too many degrees of separation between what they're saying their individual harm is and the variance. They have to show that there's someone that wants to sublease the property, that wants to operate specifically a medical marijuana dispensary in that property, that they need to have it zoned in that manner, and that they're organized in a manner to actually do that. So
you say they have to do this, but what's the authority for that?
Well, I mean, the authority for them needing to...
Why can't they? Why isn't it enough to just say we own this property, we want to lease it to someone, we think we can find someone to operate a marijuana business? Why isn't that enough?
Because, to me that seems too speculative, because there's no evidence that that's what they're actually trying to do, rather than operate their own medical marijuana dispensary. And if people could just, say the magic words, say, oh, well, we think that, 3 degrees of separation, we may want to have someone, lease this property from us, and therefore that's our harm, then standing becomes kind of meaningless, because you can just allege things of which there is no evidence or no indication in the record, and then, get standing because of that. And so I think that that's why the case law says they disapprove of speculative harm. They want to show real harm that's actually impacting the business. And we know for a fact that JD's cannot operate a medical marijuana dispensary. And we know for a fact, based on the statutory appeal, that they can't get the other 2 variances to operate a medical marijuana dispensary there.
When you say for a fact on the first one, you're asking for this as summary judgment. How do we know that they're not, how long it would take them to find someone who could satisfy that role?
Well, we know, my first one was we know for a fact that they can't operate a medical marijuana dispensary, and we know that because they're not organized as a nonprofit entity. And so for that reason, we know that they can't do that. How do we know that they can't find some some potential tenant that wants to operate that specific business in that specific place. I mean, we don't know that. It's entirely speculative, and that's why I don't think that suffices to establish standing. And then
It sounds like you disagree with opposing counsel, when I asked him the question about what comes first, the medical marijuana, the license, or...
No, I don't disagree with him, Your Honor. I do know that in order to get a medical marijuana dispensary certificate, you have to be able to present to ADHS that you have a viable place to actually house that dispensary. That's part of the application process. So I don't disagree with him on that. I just disagree with him that just the theoretical proposition that, maybe we find some tenant, and maybe that tenant wants to run that exact business, and maybe they're exactly set up to run a medical marijuana dispensary. I'm saying that is too speculative to establish standing.
But they certainly have standing to ask for a variance on their property. Which
They have standing to ask for a variance, sure, but the fact that they're not aggrieved by the... And this is, again, conflating the two issues, right? Because we're talking about the special action here. We're talking about the Sunday goods variance and not about the variance they're asking for in the statutory appeal. So we need to keep those things separate. We're talking about someone else's variance, being aggrieved by someone else having a variance. And I don't think that they've established that they have standing for that. And then very, very quickly, because I want to save the remainder of my time for Mr. Peck, I don't believe that this is a special action because what they're talking about is areas that fall within the discretion of the Planning and Development Department and its staff. By a statute, the Planning and Development Department has the discretion, as you mentioned, Judge Catani, to look at a site plan and determine whether or not there has been substantial compliance with that site plan. And they're saying that, what the staff of the Planning and Zoning Department determined was substantial compliance was somehow not. But that's not a proper basis for special action. It either needs to be, a failure to take a mandatory action or an abuse of discretion or a failure to exercise discretion when it's given to you. And none of those are happening here because the Planning and Development Department looked at what Sunday Goods had done, determined that that was substantial compliance with the site plan, and approved it accordingly. So that's well within their discretion and not the proper basis for a special action. And then one final thing is they ask for sanctions in their reply. They don't bring it up in their opening brief, so it's waived, and we won with these arguments on summary judgment, so I don't think they're frivolous. And I'll reserve the remainder of my time to Mr. Peck.
Counsel, before you're seated, I just want to make sure, I have questions about the conditional variances the county has granted.
Okay.
Should that be directed to you?
No, it should be directed to Mr. Peck.
Good morning, Your Honors. Wayne J. Peck, Deputy County Attorney. If it please the Court, just very briefly, I would remind the Court that standing has to be available at the time the action is filed. At the time the action was filed, they had no such tenant who was going to be able to operate. But that also doesn't matter because at the time they filed, no one could operate a medical marijuana facility on the property because it violated the zoning. And at the first special action, the one dismissed in 2019, I conceded to the court that on a statutory appeal, a de novo review under 816D, they would have standing to raise all of the issues that they seek to raise in the special action, but they don't have standing to raise it as a separate matter. And of course, one of the rules for a special action is you can't have an equally available remedy at law. Not only do they have it, they've availed themselves of it. So we believe that case should be dismissed. Very briefly on Your Honor's question about it being time barred, the statutory appeal is not brought under 11816, so the time bar of 11816D doesn't apply. We don't dispute that their filing under 11816 was in fact timely. Now, I would like to point out that they also, just to correct the record, they do not own the property. As the record shows, they are tenants in the property, and their right to even open a medical marijuana dispensary is subject to further approval from the landlord. So this is a whole speculative area. But getting into first the conditions, Your Honor, your question, by what authority does the statute authorize the granting of conditions? The answer is there is none. There is no common law zoning. Zoning is strictly a function of statute, and the cases are clear that if it's not in the statute, you can't do it. It's in the municipal, it's not in the county.
But you can,
Go ahead.
but you can see that the county has been essentially violating the statute by putting conditions on variance, or at least it did in this case.
No, Your Honor, I'm conceding that the Board of Adjustment did so. The Board of Adjustment, who's not a party to the action in which the county is alleging they had no authority. And Judge Catani asked questions, and in it he indicated no one's saying that the Sunday goods variance was properly granted. Fortunately for me, I don't have to defend that variance, and will remind the court that the staff, the professional staff of the county, in both cases took the position that the variance requests did not meet the statutory conditions.
Is that a position that all of the counties around the state are taking?
I
I'm putting you on the spot here, but this seems like a pretty broad, sweeping statement to say that no Board of Adjustment, the county level, can impose any conditions. And I'm curious if that's in fact what's happening around the state, or this is just something that you're now saying your county Board of Assessment has been doing improperly.
Your Honors, I can tell the court that at a lecture I gave in CLE, I pointed out that 14 of the 15 county ordinances did not conform to the statutory language, and hopefully they're adjusting that. And I got no pushback from anyone during that time telling me they thought conditions could be imposed. Part of the problem, Your Honor, is that the test in an Arizona county is a very stringent test. And if you read most of the county ordinances, they veer more towards the municipal test, which is a looser test where you can impose conditions. So when you have a standard that is right out of the statute, that you must show a peculiar condition of the property such that applying the strict requirements of the ordinance result in an unnecessary hardship, there are no conditions you could apply. In their brief, they say, we're arguing that it's either an up or down vote. That's correct. That's all the board can do.
And you're saying the bylaws are incorrect too, the bylaws that say the board may impose such conditions as deemed necessary to fully carry out provisions and intent of the zoning ordinances?
I do, Your Honor, and we argue that. First, I don't believe the board has the authority to adopt bylaws. They can adopt procedures. And second, no bylaw can expand the authority beyond that of the statute.
I guess I'm not completely following why it's such a leap from the statutory authority to grant. When you say, I'm going to give a variance, but only if you do this. I mean, if the concern is you're too close to a school, or we don't want traffic to be, it's too close to something, why not say, we'll grant the variance as long as you have the access on the other side of the property? We don't want government to do that. We don't want a board to do that. And why isn't that kind of implicit in we can grant a variance, but only if you meet a few conditions that go to our concern with being too close to something?
Well, Your Honor is asking me what it should be, and I would agree with Your Honor. I've been doing this a long time, and I will tell you that in most cases, that's how variances are obtained, and nobody goes to court, and everyone goes their merry way. But as the attorney, I have to argue the statute, and the statute does not allow that. Your Honor, there's no circumstance under which the peculiar condition of the property can result in an unnecessary hardship by applying the fact that you have to be located 1,500 feet from a park.
Well, let me give you a different example. Say there's a height restriction, and the board decides we will grant a height restriction. Does that mean, okay, we've granted a variance, you can build a 10-story building when there's a height restriction limited to 2 stories, and someone says, I'm going to build a 3-story building that's not really, that's 4 feet taller. I mean, the board can't say we will give you a variance to build it, but only if the building does not exceed the normal height for a 3-story building.
In that example, Your Honor, that could be done because case law tells us that the variance that should be granted, assuming you have a peculiar condition and applying the requirements of the ordinance resulting in necessary hardship, the variance that is granted should be the minimum necessary to alleviate the hardship. So the board could say, we find that the minimum necessary is 3 stories, not 10 stories. But in that circumstance...
It's a condition on granting a variance.
No, Your Honor, it is the actual variance that's being granted. The variance, just as in this case, the ordinance says 1,500 feet from an adult business. We are granting a variance to allow you to be 61 feet. In your example, the ordinance says you cannot exceed 30 feet. We are granting a variance to allow 35 feet. That is the variance itself. That's a mistake that JD's makes in their reply brief when they quote my advice to the board after Judge Westerhausen's decision, where I say you can't impose conditions, but you can memorialize what the variance is you granted.
In your brief, you suggest that this difference in language in the authorizing statutes for counties and cities is different, and that it's intentionally different. Do you have some support for the notion that it's intentionally different, or is it just an oversight that everyone assumes that you do have the authority to impose some reasonable conditions that help to carry out the provisions and intent of the zoning ordinance?
Your Honor, I can't tell you what the legislature was thinking, but I can tell you...
But you did say in the brief it was intentional.
Based upon my experience, that the differences between cities and counties in Arizona makes that distinction make sense. Because when you look at the statute for the cities, it's very concerned about impact on the neighbors and impact on the neighborhood, whereas the county ordinance only cares about impact on the zoning ordinance itself, because outside of Maricopa County and maybe Pima, most counties don't have neighborhoods. So yes, I believe it is intentional. It's not the only difference. For example, the governing body of a municipality can instruct the Board of Adjustment to do a lot of other things. It says so. In addition, if we were here in the statutory appeal on a municipal variance, your standard of review would be that of an appeal from an administrative agency, whereas in this case, it's de novo. That's not the only difference. There are a lot of differences, and we have to assume that the legislature intentionally did that. They easily could have cut and pasted the same language. Section 11 has been amended as recently as 2011. It was not amended for this purpose. You either meet the test or you don't meet the test in the county. In a municipality, the test is more fluid, as the court said in Porn First.
But if we were to disagree with your analysis about whether they have the authority, in your view, I mean, is that dispositive, or you think the court's ruling can be upheld even assuming the board had the authority to impose conditions?
That it could be upheld because the argument they're making is that the county had no authority, that the Board of Adjustment was the one who had to decide the conditions. The Board of Adjustment has no jurisdiction over a piece of property once it grants the variance. Our position is that this was an enforcement decision made by the appropriate authority, and all they do is disagree with it, but the record supports what was done.
Thank you, counsel.
And if I could just in 1 second, we'll rely on our brief as to why there are no peculiar conditions or an undue hardship related to the ordinance, not the items they cite. Thank you.
Thank you. Your Honor, Arizona has not determined whether the size or scope of the property is a peculiar condition, but rather it depends on the specific facts of each case. And so I can provide that citation if you'd like, but it's also in the briefing.
Okay, thank you. I'll look at the briefing.
The key point I want to make is that the Board of Adjustment has the authority to grant a variance and also revoke that variance in the event something does not occur. If the Board of Adjustment grants a variance but says we're granting it based on X, Y, Z, and if X, Y, Z doesn't happen, then we would vote not to grant the variance. And that's exactly the case here. The variance indicates, look, this variance will not be effective if construction's not completed in a year, which at the time was based on a Maricopa County ordinance. And so here, the Board of Adjustment has that authority. It makes sense that they would have
They have that authority, but haven't chosen to do anything about it, have they?
It's on its face in the variance that the variance won't run with the land if it's not complied with within the 120 days and then also the year requirement. I don't think they have to do anything.
You don't think there's some flexibility if somebody misses a deadline by 1 day?
Of course, but then it would require that party to come to the Board of Adjustment and seek an amendment or a relief from that. But I think when the Board of Adjustment indicates this variance will not be valid if X, Y, Z are not complied with, I don't think there's that wiggle room for the applicant when it doesn't take those steps, unless it seeks leave or some type of an amendment from the Board of Adjustment.
If you could go back to peculiar conditions,
Mm-hmm.
And I realize we didn't necessarily go into it with opposing counsel, but assume there had not been a variance for Sunday goods, and it's just the peculiar conditions seem to be different than just saying this is a small property when it's not the smallest lot in the area, and there seem to be plenty of other businesses that can be run on that property. What's the peculiar condition? Doesn't it have to be something to do with the property? And I apologize for being very lengthy with the question, but the briefing suggests that, gee, there's a basement on the property, and so that makes it inconvenient to do something else. But doesn't the condition have to relate to the land and not that there's a building on it right now that's not very workable?
Yeah, and so that property is zoned for large. It's an unincorporated area of the county, and it's zoned for large, I believe, farming and machinery activities. And so, with that lot being so small, it's not apt to be used for that purpose. And so that's the basis of the application. And in the event the Sunday goods variance wasn't granted on those same conditions, the appellants.
There are other industrial uses that it could be put to, other than a marijuana dispensary.
There are, however, that's for the Board of Adjustment to decide. And that's one part of our appeal that we believe a trier of fact should determine, because on one hand, the same application was granted for Sunday goods, but on the other, it was not for us.
Counsel, how do you respond to the argument that GD's doesn't have standing because it's not legally organized to operate, and also it doesn't own the property?
Yeah, it's the tenant of the property. It has beneficial use of the property. It's affected by the zoning decisions and of the county and the Board of Adjustment, and it has standing. And it's not a speculative harm that may occur at some point in the future if it is or is not able to get a tenant for a medical marijuana dispensary, because it's seeking that variance first in order to then either have a license through its own tenant, or to have someone move to that property, or be sold to someone with a license. I think we all know these licenses sell for a lot of money, and a property in that location that's a high traffic area would be very valuable, as opposed to the applications that are going for Apache County or some of our smaller and more spread out counties. Okay, thank you.
Thank you.
Thank you. Council, we thank you for your arguments. This matter will be taken under advisement, and we will now stand at recess to prepare for the next argument.